All right, let's bring in Jonathan Turley, Fox News contributor, George Washington University law professor. Jonathan, did they get it right?
Well, I think they got it right in terms of the conviction. One could have an honest debate as to whether this was a stronger manslaughter than murder case. I always view this more as a manslaughter case. But I think that few people would disagree that the evidence was overwhelming. It was a tremendous challenge for the defense. That video was played repeatedly in the trial. It just is indelible in the minds of all Americans. This is a national traumatic thing that you see and you can't unsee. So I think the jury clearly got it right, and the question will be whether there are grounds for appeals going forward.
Jonathan, you know, Steve Harrigan in his report used the word relief. And there was, for some people, relief in the verdict and what happened and the outcome there. But there's also, and we played sound of it this morning, this sense of relief that now we don't have to endure rioting across the country and violence like we saw last summer. How do we make sure the justice system works without being under the threat or the veiled threat or the overt threat of violence should it not go a certain way?
Well, I think that's what the judge in the case, Judge Cahill, was trying to say. It's astonishing that he's been attacked for saying what should be common sense, that members of Congress shouldn't fly into a highly volatile area and throw gasoline on this fire. But the greatest danger is that people will conclude they have a license to riot or cause violence if they disagree with a verdict. And that was part of the criticism of Representative Waters' comments, is her connecting this unwillingness to accept an acquittal in the same time talking about people staying in the streets and getting more confrontational.
So the president weighed in on this. Listen to this soundbite.
The knee on the neck of justice for Black Americans. Profound fear and trauma, the pain, the exhaustion that Black and brown Americans experience every single day. The murder of George Floyd launched a summer of protest we hadn't seen since the civil rights era in the 60s. Protests that unified people of every race and generation in peace and with purpose, to say enough, enough, enough of this senseless killings.
So, Jonathan, he's calling for this bill named after George Floyd, which would ban the chokehold and do away with qualified immunity for officers. From a law professor standpoint, what do you think about that, doing away with the qualified immunity?
Well, I think that we have an honest debate about qualified immunity and how far it extends. I often have to litigate against qualified immunity claims by the government. But part of the controversy over this law is going to also be the federalization of this area. The term police powers is used in federalism in constitutional law because those are powers that belong or rest with the states. States determine their own police powers, their own police practices. And in combination with the law designed to essentially federalize elections, there's a lot of sort of state-federal issues here. The question of immunity is this delicate balance. To what extent does reducing immunity then inhibit or chill the conduct of officers in situations of danger? So it's a very delicate balance, and we haven't really even started that debate.
I want to get to what happens to the other officers who obviously stood by. One was only on the job for 2 weeks, and that's going to incite, I'm sure, a lot of emotion. But President Obama said something interesting, and I say that with an eyebrow raised. Right now, it requires us to recognize that millions of our friends and family and fellow citizens live in fear that their next encounter with a law enforcement official could be their last, and requires us to do this sometimes thankless, often difficult, but always necessary work of making America we know more like the America we believe in. Do you think, do the numbers add up within law enforcement and within the Justice Department and justice community, that there's two sets of laws, one for minorities, one for whites?
Well, I do think there's a danger of overstatement. You know, many people say, let's have a debate about race, which is totally correct. We should have a debate, a discussion about race. But when people, particularly academics, try to enter that debate, they're often canceled or silenced or attacked. There have been academics that have said, look, you know, you are exaggerating some of these numbers. If we're going to have this discussion, let's understand the actual numbers involved here and the causes of shootings and how they you know, connect with socioeconomic and police issues. That debate and discussion is not happening because the minute someone gives a countervailing view, they're accused of racism. And Brian, with regard to those officers going forward, those cases are going to be much more challenging.
Absolutely.
You know, they charge people like Officer Lang. He was just put on the force. In the video, he's the one who's telling George Floyd, we'll lower the windows, we'll put on the air conditioning. He's the one who's saying maybe we need to move him so that he can breathe. He was criminally charged. But what was really interesting is on the last day of the case, in the closing arguments, the prosecutor told the jury in the court that the other officers were, quote, powerless, like the pedestrians, to do anything. It struck me as an odd statement because you usually don't prosecute the powerless. And how that prosecutor is going to square that statement when he's in court trying to convict those very same officers that he called powerless to do anything during this trial.
And let's just hope that no one convicts him, the jury, because they don't want a city to burn. That's the scenario. We can't have the jury being intimidated by sitting congressmen or presidents or former presidents.
Well, I think that's right. We've got to, I think Judge Cahill's words need to resonate with everyone. You know, it's highly ironic that Representative Waters not only threatened to undermine this case, but undermined her own case. She's suing Donald Trump for essentially doing what she's accused of doing in Minneapolis. She's has a lawsuit accusing him of violent speech and encouraging insurrection. Well, she's now going to be his best witness. I mean, how is that judge going to rule? You've got a litigant who's accused of the very same conduct who's trying to get you to rule against the former president. It's very likely the court's going to view both these situations, certainly the president's speech, as protected speech. And Waters and Swalwell and others who brought these cases may have given the president the ultimate opportunity for vindication right before the next election.
Jonathan Turley, real quick, when it comes to that speech that was given by Maxine Waters, it was referenced by the judge in the courtroom. He said himself this could open up to appeal. I know the verdict is in, and it's not necessarily time to talk appeal, but do they have a case, or is that just something that was mentioned in court?
Well, I would be surprised if they could overturn this verdict, but there are really serious questions about the judge refusing to change the venue early on, not sequestering the jury. It's not just Waters' comment. You know, during voir dire, during the selection of the jurors, for some reason, these politicians decided to announce a record settlement with the family. That had an impact. Then there was the rioting. Then there was the Wright shooting. The venue was never changed. The jurors were never sequestered. Those are legitimate issues. The question is whether they can show something concrete and whether they actually question the jurors. Did you see Waters' comments? Did you?
Can they do that?
Were you impacted by the media?
They can ask them that?
Well, they can. Usually what you do is you ask the court to poll the jury, to question the jury. I don't know if that was done, but even without that, you can raise these issues of venue. This was a media-saturated area. It was also an area of heavy rioting. I think that the judge made a mistake by not changing venue at the very start of this trial.
Why weren't they sequestered in such a high-profile case?
Yeah, I don't understand that. I thought Cahill did a very good job. I thought he was a good judge. But I think he blew that one. I think that he should have sequestered those jurors at various points. I didn't agree with him when he decided to keep the trial in Minneapolis. I didn't agree with him when he decided not to sequester the jury when that settlement came down. But then when all of this stuff was mounting, he sort of stayed the course and wouldn't sequester them. Right. I have no idea why he did that, but I think that it could have contaminated this jury.
I don't want you to get mad at me, but I was talking to a different attorney at a different time. Don't take that personal. But they said to me...
I've always suspected it, Brian.
I know. Now you have proven it. But he told me it's very expensive. It's very costly, and that could have played a role in this when you sequester a jury. So.
Yeah, it is. Also, by the way, change of venue is expensive. I did a change of venue motion, and it's very expensive to do that because you actually have to do polling of the area when you try to do a venue change. These are all very expensive items.
All right. Sorry you had to tell you that, Jonathan. But.
I bet Professor...
And on live television.
Can I ask you one question, though, about choosing the jury? Don't you choose a jury that doesn't have any information about this case? How is that possible in this case?
Yeah, that's a very good point. And judges no longer require that because you wouldn't want jurors that were completely clueless about the George Floyd case, right? I mean, these are people that have to live in a cave without any television or influence. So the key here is to question them about their bias. So we're not trying to remove them from a knowledge of a controversy, but that doesn't mean you can't take minimal steps to try to protect them, to create barriers, particularly during the trial. And I think that was part of the frustration of Judge Cahill. I think he realized that he did leave the trial vulnerable to this influence, and then who walks in? Representative Waters, and just blows the whole thing up.
Jonathan Turley, thank you so much. Talk to you soon.
Thank you.